Welcome. As I said, I'm Deborah Pearlstein. I'm a professor here at Cardozo Law School. I teach international law and constitutional law, and I direct our center for our Floersheimer Center for Constitutional Democracy, where we host events and workshops once upon a time in person, and support student activities and help inform the Cardozo community about the health of our constitutional democracy in a variety of different capacities. Our focus today is looking at the legal impact of the US response to the attacks of 9/11. For those at Cardozo 20 years ago, the events of 9/11 and our faculty shared emails about this over the last several weeks brought back really acute memories of panicked looking for loved ones and efforts to flee the city, and then grief over what turned out to be the loss of several of our alumni. And of course, so many others that day. But while 20 years at some level seem like a long time, we are, I think, still very much processing the extent to which the events of 9/11 and those that followed have shaped and are still shaping the social and cultural and political and, of course, legal life of the United States every day. Today, we have joining us an extraordinary set of panelists who are here to help us understand and to think through one set of those effects, and that is how the US response to 9/11 changed the law and lawyering around questions of national security. All of our speakers have extraordinary biographies, and I highly commend them to your attention, and they'll be available on our site. But in the interest of time and getting to our conversation, and if they'll forgive me, I want to just introduce them relatively briefly for these purposes, in alphabetical order, I suppose. Jay Johnson, Secretary Jay Johnson, was of course the former Secretary of the Department of Homeland Security under President Obama from 2013 to 2017. Before that, and arguably even more relevant for our purposes today, served as General Counsel at the Department of Defense from 2009 to 2012. So welcome, Secretary Johnson. Elisa Massimino was at Human Rights First, one of the leading human rights NGOs in the United States, for, I think, Elisa, nearly 30 years, but for the last 10, from 2008 to 2018, was Executive Director and CEO of Human Rights First, which was involved in many of these issues from the beginning after 9/11. So it's nice to see Elisa. It's wonderful to see Elisa again. Alberto Mora joins us. He is currently the Executive Director for Global Programs at the American Bar Association, but from 2001 to 2006, under the George W. Bush administration, served as Navy General Counsel. So it's wonderful to have you here and see you again. Thank you. And Ben Powell, who is currently a partner at WilmerHale, served as in the White House counsel's office under former President Bush, George W. Bush's administration from 2002 to 2006, but then was general counsel to the Director of National Intelligence, a newly created office after 9/11, where he served from 2006 to 2009. So Ben, it's wonderful to see you, and thank you so much for joining us as well. It's great to have you here. As I said, in the interest of helping us begin to have a conversation, I'm going to pose some questions, and some I'll pose directly to you, and I'm encouraging all of you to sort of jump in when you wish and as you can, so we can begin to have a dialogue as we go. But let me start just by asking each of you if you can tell me a little bit about what your work was, what kinds of matters you were working on generally on September 10th, 2011, what your day job was like, and then when and how that work began to change after the attacks of 9/11. And as folks come in, if you want to submit questions in the chat to our audience, you're welcome, or in the Q&A box, you're welcome to do that, and we will get to those a little bit later. So Secretary Johnson, I guess let me start with you if I can. What was your day job on September 10th? What kind of work were you doing, and then how did that begin to change?
Well, first of all, Deborah, thank you for including me in this great discussion. I think this is an important discussion. My literal answer to your question is that I was doing exactly the job I'm doing right now. I was a partner at the law firm of Paul Weiss, Rifkin, Wharton, and Garrison, 1285 Avenue of the Americas, at that desk behind me. And I am a partner at Paul Weiss today, 1285 Avenue of the Americas, at that desk and that bookcase. It was between my public service positions. I had been general counsel of the Department of the Air Force in the last 27 months of the Clinton administration, from October 98 to January 2001. I had come back to Paul Weiss in January 2001 and was here for the next 8 years until Obama, when I became general counsel of the Department of Defense. Now, let me get to what I think is the real thrust of your question. When I was, as Alberto knows, when you're the general counsel of a military service department, most of the lawyering is around organized, train, and equip, not war fighting. And in the period 1998 to 2001, pre 9/11, we were not at war. And most of my time at the Pentagon then was around issues of procurement, environmental law, some international law, ethics, personnel matters, the Air Force Academy, lots of issues at the Air Force Academy. And when I came back to the Pentagon post 9/11, now February 2009, the world had changed, the legal landscape had changed, and we were at war against Al-Qaeda and in Afghanistan and Iraq. And a lot of my time during the 4 years I was general counsel of DOD was helping to shape the Obama administration's legal architecture around our counterterrorism efforts in Title 10 versus something any other agency might be doing in our counterterrorism efforts. And so for me, stint 1 in the Pentagon and stint 2 in the Pentagon were radically different, both because I was at the service level first and then DOD wide second, and because we were then a nation in armed conflict against Al-Qaeda and the Taliban.
So that actually, I think, segues well to, let me ask Alberto, you were in a not entirely dissimilar legal capacity, maybe, than Secretary Johnson had been on September 10th. You were already working for the administration, for the Bush administration then?
I was. I had been confirmed to my job about 3 months before 9/11. So on 9/11, I was sitting in my office, which was in the leadership corridor of the Department of the Navy, which would become one facet over from the impact point the following day on 9/11. My job was similar to what Jay discussed his job as Air Force General Counsel. In fact, the entire team built around Gordon England, the Secretary of the Navy, was designed to attack the problem of procurement. The complexity, the slowness, the cost of military procurement was seen to be as a threat to warfighting capability, and Gordon England was determined to attack it seriously and then streamline it. My job differed from Jay's in an important way, though, because I had oversight responsibility over the Naval Criminal Investigative Service. So unlike the other Pentagon General Counsels, I had responsibility for a group that was responsible for law enforcement, counterterrorism, counterespionage, and were deeply involved in the Middle East. NCIS agents had deep regional experience. Some of them spoke Arabic. They were deeply involved in the investigation of the Cole bombing. So even before 9/11, I had attended SCIF sessions, the compartmentalized places where you discuss classified information, to review progress on the Cole bombing investigation to determine who was responsible and how to address those kinds of matters. But like Jay, I was dealing with matters that dealt with, for example, I was reviewing the the Navy's management of intellectual property. The Navy was, throughout almost all American history, have been the leader in intellectual property development. And I was interested to see to what extent we drew full value out of that kind of investment. I was involved in rationalizing the application of environmental laws and regulations to combat training in the field out in California and in Vieques and other kinds of places, because it was very restrictive. So all these things were taking my time, but that all changed in a heartbeat at 9/11.
So I want to ask more about how that began to change. I'll come back. Let me ask Ben and Elisa to answer the same questions. Sort of briefly, what kind of work you were doing before, and then when and how that started to change. For Alberto, it sounds like it changed the day of. He was in the Pentagon when it was attacked. Ben, how about you?
Yeah. So briefly, on September 10th, I was living in Sunnyvale, California. I had recently moved from DC to follow a woman who became my wife, so a smart decision there. But she had gotten a job at a well-known company in Silicon Valley, and I decided that I would move to Silicon Valley and take the California bar and leave DC behind to never be heard from again on the East Coast. So on September 10th, I was in a cubicle in Silicon Valley, worrying about software licensing deals, closing revenue for the quarter, SEC filings, all of those types of things. Because of the time difference on the West Coast, on September 11th, when I woke up that morning, I saw on the TV, because we watched TV back then, not iPads and things, I saw the reports on the World Trade Center. And there was a genre in the 90s of kind of fake news things, like the fake newscasts of the apocalypse, or kind of War of the Worlds kinds of things, for people who remember that, fake newscasts of aliens landing. And my immediate reaction was, oh my gosh, I can't believe the news is doing this kind of fake thing at this time of the morning that's really going to get people concerned. I remember distinctly that was like my initial 10-second reaction, until the horror of it really started to dawn on me. Little did I know. So what happened after that is, of course, the White House, President Bush's agenda that people don't remember were things like no child left behind, compassionate conservatism, nothing to do with kind of, terrorism was not a big focus of an election and those types of things. And you had a White House counsel's office built for those kinds of issues. In 2000, so I was reached out to in 2002, knowing a number of people and clerked or practiced with a number of people in the counsel's office, and they reached out. I was in the Air Force from 1989 to 1993 during the period of Operation Desert Shield and Desert Storm. This was before law school. I was a line officer in the Air Force, working on intelligence issues with places like Air Combat Command, Central Command, Space Command, and our fleet intelligence centers. And I worked at the FBI briefly before being a line officer in the Air Force. So that led us eventually moving back in 2002 and kind of now being thrust into the middle of, I think, a lot of the issues that we're going to talk about. One amusing kind of anecdote is when the NSA surveillance programs became quite controversial and things around FISA and domestic surveillance that I suspect we're going to talk about, a blog posted that I was the architect of these NSA domestic surveillance programs in 2001. And the Washington Post picked it up from that blog. And so ever since, I've never been able to shake that I was the architect of these NSA surveillance programs, which led my colleagues in Silicon Valley who sat next to me in cubicles to think that I was some kind of Arnold Schwarzenegger character who seemingly was worried about software licensing during the day, but at night I was designing the post-September 11th surveillance architecture. And so I just, at this point, you just kind of accept it, I guess, because you're never going to shake it once it's in the Washington Post. So
I'm happy you have the chance here to correct your record for what it's worth. That's okay. We'll come back and talk about what you did do. Elisa, you were already working in human rights, obviously by September 10th, 2001. But you hadn't much been working on these issues, I guess. When did you start?
Well, and in 2001, I was the Washington director of what was then called the Lawyers Committee for Human Rights. So I was the chief advocacy strategist for the organization, and we had our big priority on Capitol Hill was one we were so excited about. It was pushing a bill called the Refugee Protection Act, which had bipartisan co-sponsorship in both houses, and was about to be introduced, and we thought had good chance of getting passed, that would have addressed a lot of the problems that were created for refugees and asylum seekers in the 1996 immigration law. And we had a spectacular hearing over the summer, chaired by Senator Sam Brownback, who it was incredibly moving, who apologized to refugees who had been so poorly treated by the United States. And there was great energy behind that agenda. On September 10th, though, I was on a 20-hour flight back from Durban, South Africa, where I had attended my very first ever big UN conference on not the evil of terrorism, but a different one. This was the UN conference against racism, xenophobia, and other forms of discrimination and intolerance. And that was a very complicated meeting, which, there were like two meetings going on there. One was a robust agenda about the rights of migrants and about reparations for slavery, and, very encouraging, progressive. And then on the other side, where I spent most of my time, it was a meeting that erupted in horrific anti-Semitism. And it was shocking to me and profoundly depressing. And so I spent those 20 hours full of thoughts about the post-Durban agenda and how much work we had to do to repair what had happened there, to regroup and heal. And so I headed, I got back, went through New York and got back on the night of September 10th, and, was preparing. I had 3 little kids, so we were getting them all off to, the second day of school, I think, and heading into my office on Capitol Hill to put down on paper the post-Durban agenda. And actually it was my sister, who was living in London at the time, who called right before we were headed out and said, hey, I just want to make sure you made it home through New York last night, because something's going on in New York. And so we came back in the house, we were in the car. And I said, it's like Ben, I said, these things happen, some small plane probably. And we got in the car and headed down Rock Creek. I was going to drop my parents off at the airport. They were renting a car to drive to Pennsylvania to see relatives. They had been staying to take care of my kids while I was in South Africa. And we were on Rock Creek when my brother called and told us about the Pentagon. And I pulled over and we turned around and went home. And I tried to make sure that my team, who, our office was there in the Methodist building across from the Supreme Court in the Capitol, to make sure everybody got home.
So it's fascinating. This is actually quite a bit more than I expected to learn, but it's fascinating to think about not just the effects of the events we're about to talk about, but the opportunity cost of those events, where the public agenda sat before 9/11 derailed virtually everything, changed so many people's jobs and lives, certainly yours. So let me pick up then. Alberto, you were in the Pentagon on 9/11. You I think, heard and felt the plane hit the building. But as we since learned, started to learn quite a bit later, as the US began to design its response, obviously the invasion of Afghanistan, but there was quite a bit more going on. You had worries early on. What worried you? And you've just been appointed, you've just taken this job, you're working for the president who's appointed you. What do you, if you're concerned about the development of policy direction, what do you do about it? What can you do about it?
Well, these were not responsibilities of the services, because those kinds of policy issues rested with the Department of Defense and then the combatant commanders in the military chain of command. My job was different, though, because as I mentioned, I had responsibility over the Naval Criminal Investigative Service. And NCIS, because they had developed a close working relationship with the FBI during the Cole investigation bombing, were regarded by the FBI as a respected peer outfit, which moreover had experience in the region and working on all these literal Muslim Arab countries in the region. They were invited into FBI Director Robert Mueller's 8 a.m. morning briefing to discuss the domestic terrorism picture on the very next day. And then NCIS would come back from Director Mueller's office and brief me on the domestic terrorism picture. And then in the next hour, I would go into the Secretary of the Navy's office, where he would be briefed by Navy Marine Corps intel officers on the international terrorism picture and the force posture of the American military. So for about a year and a half after 9/11, I spent 2 hours every morning looking at intelligence and then counterterrorism intel information, and then evaluating the performance of NCIS, both individually and then in conjunction with other DoD law enforcement and counterterrorism activities, as well as the rest of the U.S. intelligence community. So my day in my life after 9/11 was marked by deep operational involvement in the war on terror in various different dimensions, which was a different set of responsibility than most attorneys in Washington at that time, even in government, had. That was the change. I would not get involved in policy discussions otherwise until the Department of the Navy was invited by Secretary Rumsfeld to get more involved in detainee treatment matters in Guantanamo. But that only happened in 2002. So during that year, other than my NCIS responsibility, I really had no contact whatsoever or involvement in the larger policy issues dealing with legal policy to fight the war on terror.
So publicly, right, there's some understanding. I remember seeing the first reports of detainee death by blunt force trauma in, I think, late 2002, right? And the Washington Post picks this up. It begins to be clear that Guantanamo and elsewhere ultimately will detain tens of thousands of people over the course of the wars in Afghanistan and Iraq, that there's cruelty going on, that people, right, are being, some of them beaten to death, that some of them are being tortured. How do you obviously become aware of this at some point? How do you begin to think about what to do about it? You're worried, what do you do?
Well, what happened, Deborah, was in November of 2002, on some other meeting in my office, the NCIS director took me aside and said, kind of quietly, he said, look, we're hearing rumors that detainees are being abused in Guantanamo. Do you want to hear more? A very elegant way to let a political appointee either say I'm in or say I'm out. No, it's not my responsibility. I think I'll pass this issue up. But my response to him was, I need to know more. So my view of my responsibilities as general counsel was to fly to areas of potential illegality, so as to do my job as a lawyer and protect the agency and Department of Defense. The next day, he came back in with some of his agents who were assigned in Guantanamo, involved in the interrogation processes. There were two task forces, one criminal interrogation task force, the other one was a military intelligence task force that was designed to elicit actionable intelligence for use in the warfighting effort. Our people were assigned to the criminal investigation task force. And then in the course of about an hour and a half, they painted a story about all the data they had obtained and the rumors they had gathered about the interrogation of some detainees, not all of them, some detainees. And what they had heard was that the people at the highest levels, and they didn't know what that meant, had authorized the use of brutality in the interrogation of prisoners. They had gone snooping. They had not been present in any of these interrogation sessions, but they went snooping around Guantanamo. They actually stole some interrogation transcripts from what many years later I would learn would be one of the interrogations of Al-Qahtani. So this was the interrogation where female guards were straddling Al-Qahtani, putting women's underwear on his head and taunting him sexually. And this wasn't necessarily, obviously not cruel treatment per se, but it was abusive, and it was a violation of standard operating procedures. And what it did indicate to me was that what I felt at the time was that there were rogue guards, rogue interrogators that were not sufficiently supervised, angry at what happened in 9/11, fearful of further attacks and desperate to find additional information, who had been given the latitude to brutalize prisoners in the course of interrogation. The very next day, I called the only person who I thought would have some information about this. That was the Army General Counsel. I asked him the classic investigative question, I'm hearing rumors that people are being abused. Do you know anything about that? Typically, when you ask that question, people always say no, even if they've got a whip in their hand or in a jail cell someplace. In this case, the General Counsel said, I know a lot about it, come down. And the next day, he handed me a copy of the memorandum that Donald Rumsfeld had signed, authorizing the use of counter-resistance interrogation techniques, which were very similar to the enhanced interrogation techniques that the CIA was, unbeknownst to us, proposing. And then Rumsfeld had authorized the use of those techniques. And then in a handwritten comment said, I stand at my desk from 6 to 8 hours a day. Why are they limited in standing 2 to 4 hours a day? And that's what threw me into all of this. My quick review of the memorandum led me to conclude almost immediately that this was an incompetent piece of legal analysis. The legal memo provided by Army JAG in Guantanamo that found that the application of these interrogation techniques were lawful, either under Geneva, U.S. domestic law, or international law, and thus could be applied without any legal concern. That was the memorandum that was adopted by Southcom, then adopted implicitly by the Joint Chiefs of Staff legal group, and then taken by the DoD General Counsel, sent to Donald Rumsfeld, and then approved by Secretary Rumsfeld. That was the legal basis for the abusive interrogation, and I felt that was, as I mentioned, an incompetent piece of work that had potentially opened the door for torture and consequently criminal liability, potential criminal liability by anybody associated with the authorization to use those techniques or their application.
So let me just follow up with first Ben and then Elisa. And Elisa, if we lose you because of your battery, we'll look for you by phone soon thereafter. Ben, you're there in the relatively early years. You're in a completely different sort of bucket, or at least office in the White House, and then much later in the DNI's office. So Alberto's finding this out. I don't know to what extent you had visibility into any of this. I know you were mostly focusing on surveillance, if not designing the entire program yourself. How do you conceive your role as counsel? Alberto was talking about, look, I'm doing this as an investigator in my capacity as overseeing this. There are internal steps I can take and was taking, even as I'm discovering this about other people I'm working with or know of. How do you conceive your role as a lawyer in the White House at this moment in the intelligence community?
Yeah, so a couple things. First, I am around this in the White House, but all of this, I'll put aside the DoD programs for a second, but things around the CIA, things around the NSA programs, all of this is extremely compartmented, extremely closely held, not just at the White House, but at the Department of Justice, the Office of Legal Counsel, I believe also in some ways in DoD and certainly within the intelligence community. So while I'm working on a variety of things related to intelligence changes and transformation and initiatives, you're reading in the papers about people being picked up, and then you just read in the papers that these people have been picked up and by somebody located somewhere. And then, of course, you see more and more about the interrogation programs and issues coming up. But these things were extremely closely held. And I think one of the lessons, I'm sure we'll get to a variety of lessons here, was you do wonder if there had been additional legal analysis, additional input into these, would it have benefited and prevented some of the things that went on that clearly were not authorized, that clearly went beyond law, and all of those types of issues. So let me fast forward, though, to January of 2006. As my first day on the job, I'm fully briefed into the NSA terrorist surveillance program, as we called it. Others would call it the domestic warrantless wiretapping program. Briefed into the detainees that are at the so-called black sites, and had been subject to the enhanced interrogation program at the CIA, and a variety of other programs. So as you can imagine, January of 2006 was quite a day, as the whole aperture is now open to you, and you're asking, okay, so what is our plan with these detainees at these so-called black sites? And the answer you get is that shrug emoji. And then you ask, well, what's our plan now that the New York Times in December of 2015 has blown a very highly compartmented NSA program involving domestic surveillance of communications? And what's our plan there? And you get the shrug emoji. So it was quite a first day on the job. The first question I got, even before I was briefed, was from a CIA lawyer who turned to everyone in the room and said, have we gotten Ben liability insurance yet? And then somebody said, no, he hasn't signed up yet. And they said, well, you better get him the insurance really quickly before we start this. So that was my first day on the job, learning about a variety of these things, some of which Alberto talked about, but kind of opening the aperture to the whole piece of this. You knew in the White House counsel's office that there was a variety of things going on because you were reading about them through leaks regularly. Obviously, there was a big story in the Washington Post about the CIA interrogation program. There was the New York Times article and those types of things. But there were so many things going on that you didn't know which crisis the closed door meeting was about. Was it about Condi Rice and whether or not she's going to testify before the 9/11 Commission in public forum? Was it about making the August 2001 PDB text available publicly? And I was dealing with my issues about how are we going to reorganize the intelligence community. And of course, you forget about I was the primary liaison to examining the Iraq intelligence failures and the commission on that, and briefing President Bush on all of the different intelligence issues that resulted from that. So it's a long way of saying is, until January of 2006, I was a bit of an observer, strangely enough. And when you look back at memoirs and those kinds of things, these things were tightly held to the counsel to the president and are just a small group of additional officials in the White House.
So Elisa, from the outside, right, this is, and Jay, I have some recollection that you were beginning to do sort of pro bono briefs in this space, maybe while this was going on, but Elisa, from the outside, the internal knowledge and debates are largely invisible as this is all unfolding, but it's becoming clear, right? We've rounded up, the United States has rounded up and detained thousands of Muslim and Arab immigrants here in the United States. We're detaining 2 American citizens as enemy combatants without access to counsel, without charges. There are reports of detainee deaths. There are beginning to be reports of torture publicly. As a human rights lawyer, how do you think about where to start? right?
Yeah.
Presumably these are all human rights concerns. What, how do you begin to craft an approach? What do you take on first? And what's the hardest part of knowing what to do?
Well, a few days after 9/11, I was in a standing room only meeting in the basement of the Mott House, where the ACLU was headquartered in DC, across the street from the Supreme Court, with an incredibly broad range of organizations that had come together to mourn the loss of life, but also to talk about the risks that we knew were coming. And this was a group that really, it ranged from, Phyllis Schlafly's Eagle Forum folks to People for the American Way. It was a huge group of organizations that came together and within a day or two agreed on 10 principles, a kind of a statement and a warning and a plea to the government and to the American public to remember our values and the need for transparency and the need, for the rule of law. So we tried at the very beginning to pull people together. I don't know if a meeting like that could actually happen today. It's kind of hard to imagine, frankly. But we were all in shock and mourning, but we all were, thinking about what's coming down the road. We imagined all kinds of things that might happen: martial law, rounding up of immigrants, that kind of thing. We never imagined that the President of the United States would authorize and defend the use of torture. That never came up. We kind of felt that was, the US had ratified the Convention Against Torture in the 90s, and we thought that was solid and put to bed. So one lesson we learned from that is these fights don't end. But most of my career up to that point was focused either on refugee protection, but on US foreign policy and the human rights abuses of other governments. And all of a sudden, when I spoke to my friends in these countries who were human rights activists and said, how can we help you? And they all said the same thing: get your own house in order. How the US responds to this will have repercussions for all of us, for the whole world. And please get it right. And so we knew we had to shift. It was hard for me to let go of that Refugee Protection Act agenda. It took me a couple of months before I, finally realized that the time has passed for that. But I had to learn a whole new area of law. I think I had maybe been in the Pentagon once. I didn't know the Armed Services Committees very well on the Hill. I dealt mostly with the State Department and the Justice Department. Those were the two places where I spent my time, and those relevant committees on the Hill. I did not, have a copy of the Geneva Conventions. I didn't know about Common Article 3. I had to learn all that stuff. It was like remember after the Washington Post story, the Dana Priest story about the treatment of detainees with anonymous sources, we had our first meeting over at the Pentagon with the folks in the DoD General Counsel's office. And it was the strangest meeting. I've never had another meeting quite like that meeting. We walked in and the government officials, the General Counsel, the Assistant General Counsel, told us that the meeting was going to be recorded, videotaped. And we didn't know what to say about that. We accepted it. But we went in there with the view that these reports must be false, that this is the US wouldn't do that. And that the president should get ahead of it right now and say, this is not who we are, heads will roll. These are anonymous. We thought it was people just bragging, retribution, that kind of thing. And instead, we were kind of read the riot act by the DOD lawyers. How dare you? How dare you accuse the United States government of doing this kind of thing? You know, basically, get the hell out of here. It was a shocking meeting, and it really reshaped for me my entire orientation of what we were going to need to do as a human rights organization based in the United States.
So there follows
Deborah, could I say something?
Please, yeah, I was about to turn to you next, so go right ahead.
Yes, before you ask your question,
Yeah.
and listening to the comments, I really want to point out what the role of an executive branch lawyer in national security should be in difficult, stressful times. And because I think this underlies this whole discussion. When I came into, and I've been both a lawyer and a client. When I was the cabinet secretary, I was the client. And most lawyers don't want to have clients who've been lawyers, but I was both. And when I came into office with Obama in 2009, we lawyers were at an advantage because President Obama was himself a lawyer and was determined that the lawyers should have access to everything. And I did, I think, have access to virtually everything that went on in the Department of Defense, and a lot that went on in the intelligence community as well. And I was determined that we should not shape the law to fit the facts and strive to apply traditional legal principles to an unconventional enemy. And in that way, our actions would be the most credible. One of the differences I noticed one of the things I noticed about those in the JAG community who had been lawyering during the Bush years versus the approach we wanted them to take was very often the JAGs would ask, is there anything that would prohibit me from doing what we want to do? My question to them was, that's the wrong question. It's, what is the authority for doing what it is you want to do? Now, the Bush team, I have to say, right after 9/11, a lot of these rules and a lot of the perceived legal limits, they were writing on a blank slate in uncharted territory. And there were Supreme Court precedents developed during those times that helped establish the legal limits. So by the time we came into office in 2009, the parameters of what the executive branch could do in the so-called war on terror were beginning to take shape. So we had that advantage when I came into office. When I came into office in February 2009, I'll never forget, I was probably in office only 2 or 3 weeks, and I had never dealt with anything like this at the service level. 3 guys from Special Ops came into my office on a Friday afternoon. Stuff in the Pentagon always happens on Friday afternoons. And they came in, and my deputy, Dan DeLordo, who had been there during Clinton, he had been there all through Bush, Alberto knows him well, was standing there. And the Special Ops guys came in with what they refer to as a baseball card. It was a PowerPoint slide, and it had the identity of a known terrorist, his photograph, his last known location, his terrorist affiliations, his terrorist activities, the munitions that the military had intended to use for the strike. And they showed me all of this. And I was listening, and I thought to myself, well, this is very interesting. Okay, why are you here? And Dan said, they're waiting for you to tell them it's okay to kill him. Nothing in private law practice in this office or any place else can prepare one for a moment like that. And that's for the law students listening here. And from that moment on, I realized the gravity of the job I had taken on. And there were moments when I said, no, there is not legal authority for this particular operation. President Obama wanted us on the domestic legal side to the full extent possible, rely upon our statutory authorities, the 2001 AUMF, and not his perceived Article 2 constitutional authority to apply lethal force. And so there were times when I said, no, this does not fit this particular objective, this particular organization, this particular target does not fit within the AUMF. Sorry, guys. And that sent a shockwave through the whole chain of command, but it actually had the effect of focusing the chain of command on the need to get legal approval all the way up the chain for everything they wanted to do. If the Secretary of Defense had to approve it, I had to approve it. If the president had to approve a Title 10 military operation, I had to approve it. And therefore, everybody in the chain of command worked a lot harder to prepare their case for a particular operation. And they knew that I was going to be the stop on the train that they had to prepare most for, because I was going to ask the hardest questions.
So this puts lawyers, there are a bunch of questions that raises, and I want to maybe come back to some of them, but the story you've just told, right, puts lawyers in this absolute center of the decision-making loop. And the same was true at some level in the Bush administration, in that you'd see the role of folks like John Yoo and other also lawyers in the Bush administration at that time who were crafting dramatic new theories of, you know, the president doesn't have to pay attention to criminal prohibitions against torture because he's the president. And so on the one hand, does that always work? Why does that work? But then on the other hand, right, what do you say to critics today who say, and this is folks like Sam Moyn, who has a Yale law professor who has a new book out, but also folks like Jack Goldsmith, who I know you know, who say, look, all these efforts to constrain, to apply legal constraints to detention and interrogation and so forth, actually had a counterproductive effect, right? In Jack Goldsmith's account, the constraints that were successfully applied to detention and interrogation by, you know, pushback efforts through the Bush administration drove the Obama administration to pursue drone strikes instead, right? The constraints on intelligence gathering through surveillance drives, you know, human collection intelligence gathering through other means. And most dramatically today, right, Sam Moyn's book argues that efforts to apply the laws of war in war, right, as opposed to challenging the inhumanity of war full stop, confronting it, allowing its inhumanity to flow, actually made the war drag on longer, right? That however well-meaning all of these efforts were, their effects in different ways have been counterproductive. Now, let me start with, since I asked you, Secretary Johnson, to start, what piece of that you want, and then I want to let the other folks respond.
So there's a larger discussion we can have about presidential war powers and how the president's perceived Article 2 war powers have greatly expanded over the last 20 years to a point that I don't even recognize anymore. But the direct answer to your question is no, it does not always work. And in times of stress, lawyers in the executive branch who don't get a lot of oversight from the courts or the Congress very often have to do better than just come up with theories for how something could work. And I'm sure every lawyer on this program, on this panel, will agree with me. It's not simply a matter of coming up with something that is a decent on paper theory for, you know, for example, why enhanced interrogation is okay, or why it's okay to move money from the Department of Defense to the Department of Homeland Security to build a wall. You've got to do better than come up with a theory. You have to come up with a sustainable, rational, legal basis for doing something that will stand the test of time and will stand all of the incoming criticism you're going to take when that legal theory eventually emerges in Congress or the Washington Post or someplace else. And so I used to ask myself, if I was asked about the legality of something, could I imagine myself testifying before the Senate Armed Services Committee defending that legal position. And if my answer was yes, I was comfortable. If my answer was no, this is really a stretch and I can't, my answer ended up being no. Now, I'm going to disagree on the point you made about how, in some way, applying a legal constraint then led to a plethora or an enlarged use of targeted lethal force, i.e. drones.
So Jack Goldsmith's argument, I don't want to take credit for
Yeah,
it.
I mean, Jack and I are good friends, and I've never quite heard Jack put it that way, but I'll give you my own perspective. Targeted lethal force, and whether it's an unmanned aerial vehicle or a targeted missile off the deck of a Marine ship, Navy ship, is a way in which there is a temptation, there could be a temptation to use that as a convenient alternative to criminal justice. Capturing somebody, bringing them to the United States, trying them in an Article 3 court, and we have to guard against that. But the applications of targeted lethal force during my watch, and I believe others, minimized collateral damage. Where, put aside what happened in Afghanistan a couple of weeks ago, we don't know all the facts yet, but through our enhanced technology, targeted lethal force can minimize collateral damage and get the precise target you are after when used appropriately. What makes people uncomfortable about drones is that they see it as something where there is a temptation to make it an alternative to criminal justice, bringing someone to justice versus bringing justice to them, as they say. And because there's nobody in harm's way, there's no pilot in harm's way. My counter to that is that that's a lot more productive than taking on an entire city block, because you've got a high value target in the middle of that crowded city block. And we have to, in good faith, do our best to see that use of targeted lethal force is the exception and not the rule in how we go after terrorists or chasing bad guys generally. I said a lot, sorry.
No, thank you. Let me ask Alberto and Ben to pick up on any piece of that, right? I asked him a whole bunch of questions at once, which is unfair. But both about what lawyers can do, what lawyers can genuinely do to affect the course of US foreign policy conduct, or at least in these particular contexts, and whether lawyers should worry more about the potential sort of adverse consequences, even unintended adverse consequences of what their legal theories are when the stakes are so very high.
So Deborah, I haven't read Moyne's work yet, so I make that kind of disclaimer. But the thesis that he's articulated sounds to me just completely wrong and unsustainable for lots of reasons. First of all, let's take a look at the Bush administration's legal architecture to fight the war on terror. It's an architecture that embraced torture as a weapon of war. State decision to use state torture. This is, now clear. There's no further debate as to whether it was torture, or any further debate as to whether it was expressly adopted by the Bush administration. Albert Camus, in writing about French use of torture in Algeria, wrote that it's important for a nation defending itself not to adopt those weapons that would destroy what it's trying to protect. And I cite that quote because I think this is what the United States inadvertently did when we used torture as a weapon of war and adopted other techniques. And let me give you an example of how this works. I was at an international military legal conference in Singapore in 2005, I think it was, when I was all of a sudden surrounded by the uniformed TJAGs of UK, Canada, Australia, and New Zealand. So these are our closest allies and our closest partners in the international coalition to fight the war on terror. I was literally against a corner, And one of the JAGs, I think it was the Brit, put his finger in my chest and he said, look, what you as the senior American here need to know is that our nations will, the cooperation of our nations with yours across the range of military, intelligence, and law enforcement activities in the war on terror will continue to decline if you can continue to abuse prisoners the way you're abusing them. So I had not been in, since I was not in the military chain of command, I had been involved in the Guantanamo debate that we thought had been resolved satisfactorily. I was kind of stunned by this because I thought we had put to bed the use of abusive interrogation techniques, but what these individuals, and by the way, these officers came to me not because they got together at the bar and decided, let's go talk to the American about this. No, this was a deliberate message cleared and authorized and directed by higher authority in each of the countries, because the issue about American torture was discussed at the prime ministerial level, cabinet level, and in all of our allied countries during the course of the war, when it became evident that the United States was using and was insistent on using torture during the course of the war. What the Allies were telling me is that you're advancing a legal architecture to fight this war. We're not buying it. We're not going to subscribe to your notions of torture. And why? Because the prohibition against torture was a civilizational achievement. We were not fighting the war on terror to make the world more cruel. And yet the use of torture in fighting the war and to breaking down the architecture of human rights, which we had been lobbying for and working for 50 years, was made incoherent when the Bush administration decided that torture was consistent with human rights around the world. In fact, I asked this question of the DoD General Counsel during one of our debates is, who made the decision that it's in the national interest to be able to abuse prisoners, have 24 prisoners in interrogation dungeons, in contrast to continuing to advance a human rights policy that has yielded such great benefit to our nation over the last 50 years? Who made this policy decision? Well, it turned out that torture not only made human rights advocacy incoherent because of the importance of the prohibition against torture within that kind of architecture, but the allies we had enlisted to fight the war on terror found that it was contrary to their values. It would impede their collaboration in the war on terror. And what's more, as numerous American military leaders has talked to Stanley McChrystal, for example, he found out that the use of cruelty in the waging of war, and particularly in the detention of prisoners, really had contrary effects because it would alienate the population, it would reduce the level of intelligence, and it would reduce the combat efficiency of American forces in the field. So there are lots of reasons, meaning there are tactical reasons not to use torture, there were operational reasons, and there were strategic reasons, both on the military level and on the political level, in terms of coalition fighting this particular war. The decision to use torture damaged the United States, made us weaker, created American casualties, and then created a situation where America, because of loss of popularity, was less able to mobilize international public opinion on perhaps that. I could go on, but the point is that if Moyne's thesis is you can fight inhumanely and achieve greater objectives, well, the evidence of the war on terror and many other wars, the French in Algeria, the British in Northern Ireland, all serve to indicate that use of abusive techniques in combat is counterproductive to the stated objectives.
I'm sorry he's not here to hear that critique. We should
Deborah, when I was, I was at one of our detention facilities, DOD detention facilities, I can't remember whether it was Iraq or Afghanistan, after President Obama had banned enhanced interrogation techniques. And one of the detainees was being interrogated. He came out of the room and he said, well, if that's the worst you're going to do to me, I'm on the wrong side.
Ben, let me give you an opportunity to jump into the conversation, and then I'm going to pose one last question because I suspect it's going to give you all even more to say. So I will let you respond to this last round, and then give everybody one more round. So Ben, do you want to either respond? You can respond to Moyne's critique or the overarching question about what lawyers can usefully do here.
Yeah. So boy, a lot in the comments here. I probably go on until about 7 p.m. and I'll be the last one here as I talk away. But let me try to briefly address a lot there. On Jack's critique and the drones, my perspective on that. You could either say we didn't solve the detention problem, or you could take a view and say, well, yes, we did, Ben. We did solve the detention issues, because what we do now is we have a paradigm, which is we either detain people in the criminal justice system and try them in an Article 3 court, or there's the option in only certain circumstances, hopefully exceptional circumstances, where there is a drone strike or the use of lethal force against someone overseas. So that's where we have settled right now. And that has been what the instructions, implicitly or explicitly, to the intelligence and defense establishment has been, and the bureaucracies react to that. So the idea that somebody who wants to see their career continue is going to be generating capture packages, which inevitably generate the question of, we know this person is cooking up explosives. We know they're trying to figure out how to put them in printers or other things that we've read about, but yet for a variety of reasons, we can't put them in an Article 3 court. It would require, blowing our most critical sources and methods of intelligence. It is something that would not work for a variety of reasons in an Article 3 court. But we know, to whatever level of probability you want to put on it, 95%, 98%, 99%, 100%, that this person does pose an imminent threat and is actively working to kill Americans. Where are we going to put that person? And we don't have an answer as a country to that question. Or you could say we do have an answer, Ben, which is, that's the way it is. If we can't prosecute them, we can't prosecute them. And so depending on your values and other things, you may find that satisfactory or not. But frankly, no one's generating capture packages for that individual if they can't be brought to the Southern District of New York and prosecuted. And you can think that's a good thing or a bad thing. So what are we doing? What is the result of a lethal strike? First, there's always the potential for collateral damage. No one, like the US military, and the intelligence community, goes to the extreme lengths to vet target packages, to do the things that Secretary Johnson said. So an amazing thing, and any number of things that have been called off to try to prevent and minimize any collateral damage. But the world is messy, and unfortunately, from time to time, there is collateral damage. The second result of that is loss of intelligence. And everyone watching this appreciates how much of your life is on your phone and on your laptop. It used to be, before all that, it was pocket litter, right? What you had in your pockets as a terrorist, and what was your contacts book and those types of things. So to the extent all of that becomes vaporized, that's a loss of intelligence. So we shouldn't pretend that not having a detention and capture option somehow is cost-free, like, oh, well, this is the perfect world, we've solved the problem. There are downsides and there are costs to that. Now, as a country, we've made a judgment that we do not at this point want kind of a detention system that stands apart from Article 3 under some kind of military or laws of war type of detention system, right? And so, but we shouldn't pretend that is cost-free. We all want cost-free solutions, right? That we can all agree on and say, well, this is an easy thing. A lot of this grows out of the experience that the agencies went through with the detention and interrogations. And Alberta and I would probably have to have a complete separate debate in panel about whether the Bush administration adopted torture as a instrument of war and those types of things. I'll just leave responding to all that for a separate time. But what I will say is, I suspect, and he may or may not agree on this, is none of these agencies really, in 2001, and Secretary Johnson alluded to this, they all were writing on a blank slate. The CIA was writing on a blank slate. We were in these failed states encountering people on the battlefield, picking them up for a variety of reasons. There were a variety of authorized and apparently unauthorized interrogation approaches going on, and we've read about the abuses of all of those things. I will say this, I think there was some idea that you could somehow separate in the public's mind the idea that you would have, for example, a very small CIA program with techniques, again, that we can all have a separate debate on. And somehow you could also have enlisted people in the military engaging in certain techniques and doing things. And then you would have other parts of agencies picking up people on the battlefield and detaining and interrogating them. And there was all this information being passed around about what was authorized, what was unauthorized, and all of those things. And then you have the horror of Abu Ghraib, all of this putting it into a completely combustible mix. And I recall a phone call where someone was explaining to me, but Ben, this is the CIA high value program. That's not these other things that you're talking about where abuses happened, where people died and everything. And I said, well, respectfully, I don't think people see it the same way that you do and are making the distinctions that you are making. And we have to deal with that fact, whether or not we think it's fair or not fair. But, you know, it is all kind of now put together, and you know, we suffer from that today, and that of course has led us to where we are right now as a country in terms of these options. You know, apparently, you know, we still suffer. We still, you know, have the same meetings apparently that the government has had now since 2001, which is we have these ISIS detainees in Syria or in the Kurdish regions. They're really bad. What are we going to do? And everyone's like, yeah, I don't know. We can't prosecute them for a variety of reasons. So what are we going to do? We had people at Bagram, of course, are now free. Now those people at Bagram were, I guess, detained by the Afghan national government eventually. But you know, we have decided not to have a detention system to deal with terrorism, but I don't think it's cost free.
So that actually brings us directly to the last question that I want to pose for all of you. And that is how this is still playing out today. So among the many reflections on 9/11 and what it's wrought and what this era has wrought, so Spencer Ackerman, among other authors right now, right, he has a book out, but I've seen other articles making this point, argue that the model that we pursued post 9/11, not just the war model versus the criminal model, but the sort of with us or against us model, the creation of a Department of Homeland Security that puts terrorism and immigration in the same agency and then links them together as a matter of policies, or at least practices of cruelty and torture, followed by, for the most part, official impunity, right, for those actions, and the general state of fear, the fear that I know we can all recall from the day of the other and who's against us and what's to be done if we do nothing. That these, you know, in Spencer Ackerman's book, he says, the way he puts it is, the war on terror revitalized the most barbarous currents in American history, gave them renewed purpose, and set them on the march, an army in search of its general. Right? He's trying to make the case, and it's a dramatic one, right? But that these sort of currents that one saw manifested in our national security policy in different ways laid the groundwork for the election of Trump, the social division that we see today, and this sort of general approach to the world and the divisions we see sort of tearing the country apart and challenging democracy today. Now, that's a very broadly stated case, but one could pick up on narrower pieces of that and ask, right, was our approach to Arab and Muslim immigrants and our toleration at some level of cruelty to these populations, whether in the United States or abroad, and our sort of policy approach to this universe post 9/11, did it bring us to the point where the issues we see manifest on our own streets in very different ways today? I guess, Elisa, I know you switched to your phone, which is great, but let me start with you and then give everybody else a chance to engage.
Well, can you hear me okay?
Yeah, it's great.
So I haven't read Ackerman's book, and I haven't read Moyne's book. I guess based on what you just said about Ackerman's argument, I would say, of course, our responses to 9/11 didn't help all those strains in the, U.S. Culture and character. But I think it's a bit much to say that, that it directly caused where we find ourselves now. I think, that that ugliness, fear of the other, I'm at my organization, my former organization, we spent most of our, about half the organization's resources has always gone to working on immigration and refugee issues. So we were, quite attuned to the level of racism and xenophobia way before 9/11. And yes, I mean, I think that, it touched a nerve in a strain in the American character that is ugly and unfortunate. It also, I think, there's kind of an ebb and flow in our history as a country. I'll never forget the meeting that I had with Jim Ziegler, who had been on also a new Bush administration appointee, had been on the job, I don't know, a couple months, maybe not even, when 9/11 happened. And I had set up a meeting with him before 9/11 for early October. And to talk about immigration issues and fixing immigration detention and all of that. And I thought he would cancel the meeting, but he didn't. And we walked into the meeting with some board leadership from the Lawyers Committee, and he had just come back from being raked over the coals on Capitol Hill about, the immigration status of some of the attackers. And I started the meeting by saying, thank you for keeping this meeting. We made this meeting before the whole world changed. And he slammed his hand on the table and he said, the whole world has not changed. We got attacked in a horrible way. Thousands of our people died. But God help us if we allow that to change who we are and the whole world. And it was, really, it stuck with me for, many years after that. The sense that our values are a strength in the fight against a terrorist enemy. So, and also this either or thing that Moyne seems to pose about, the constraining war through law somehow just enables it to be worse. Or I think, it's
Go on longer.
You have to do both, right? The law makes a difference. It's important. And as you you led that program at Human Rights First in the early days. We worked really, really hard to maintain a framework of law, because we knew how, from past episodes in U.S. history, how important that was. The thing that I learned that I didn't know before 9/11 and the aftermath is I knew about the importance of the law. What I didn't know was how important individual lawyers could be, for better or for worse. Lawyers as people with professional and personal ethical codes made, or lack thereof, made the difference. Jay talked about telling lawyers that they were asking the wrong questions. That is really profound. And when the torture memos came out, and then when Alberto's famous memo was written about by Jane Mayer and made public, I took those two memos and I sent them together to all of my friends who were government lawyers. And I said, there's the law, but there's also who you are as a lawyer, what it means to be a government lawyer. And, you know, so that's something that I think lawyers and law students should be thinking about. I still want Alberto to teach the class on what is the role of a government lawyer. I don't think we equip young lawyers enough with those questions. And, you know, advocates also have ethical questions, human rights advocates that often go unexplored or unaddressed. You know, Ben raised some of those things about, you know, these choices are not cost-free. So I think those are some of the lessons that we are still processing, but need to, you know, follow through on, because we know that this is not the last time that our values will be challenged, and we have to be prepared. And lawyers have such an important role to play in making sure that we don't make those mistakes again.
I couldn't ask for a better message to law students. Thank you. Let me ask the others, Alberto, Ben, Secretary Johnson, just in response to either the question of the extent to which our response to 9/11 has at some level caused or accelerated or contributed to the current dilemmas we find ourselves and our political lives driven by today, or for that matter, anything Elisa just said. And I'll ask for those of you who are able, I know there's some technical issues, but those of you who are able to submit any questions in the Q&A, please go right ahead, because otherwise I can certainly keep them busy for 9 more minutes. Go ahead. In response to the Ackerman critique, for example.
To me, I'm happy to start briefly.
Sure.
Let me just say something optimistic, because I wouldn't want, you know, and every article's like, look at and so many books that are now coming out and all of those things, but a couple of points. And my gosh, we could talk about lessons learned and mistakes, and, you know, I'm certainly familiar with the Iraq intelligence failures, having been the one to brief the president on that and to be the primary liaison to the commission on that, and a whole separate panel on, you know, the Iraq war and all of the strong feelings about all of these things. But just a couple of quick points. We have not had a large-scale domestic attack across multiple administrations, across different parties. And that, I think, is undeniable because of changes that the government has made to prevent those attacks and the work of our defense and intelligence communities and the whole of government effort. So we're all lawyers, and we spend all of our time listing on the 10,000 problems. And Secretary Johnson, you know, I'm sure receives it all the time to this day about TSA and complaints about every single piece. But you know, while Spencer and others are doing what I'll call alternative histories of, if we'd done it this way and if we'd done it this way, it all would have worked out. There's an alternative history of what if 3 more planes came down over the past 10 years. And I can go through all of the things that Secretary Johnson would read about, I'm sure, in his morning gloom and doom book about all of the threats that are out there. And what the public could demand and what that would do to our society. I always worried about if there were other mass casualty attacks. And I don't think, and I don't buy into, it was not hype. It was not just people making that up. There are people out there that are intent on causing harm and causing harm domestically. And we're very fortunate that that didn't happen. We've had some very close calls. If the shoe bomb had gone off on the plane on approach to Detroit in December of 2009, if the explosive, if he had gotten that right in Times Square, what would have happened there? And I can keep going down the list. So the government made a lot of choices and reorganized in a lot of different ways, changed information sharing. We went to the Congress and got a completely new signals intelligence regime under the FISA Amendments Act. From news reports, that makes up at 1.40 to 60% of the intelligence that's provided to the president every day in his daily brief. We did DHS. There's a whole variety of things the government did. And I'm not sure we would be having this debate or discussion on the same plane if we had had additional attacks. So I think while there seems to be kind of this plethora of like, look at all the mistakes over the past 20 years and we should have done things differently and all of that, that there's a lot to be said there, but it is not all a bad news story. And the fact that I think a lot of people moved beyond 2001 and September 11th is due to the fact that we haven't had additional attacks. And I don't think it's because of luck, or because the people who want to do this had just simply disappeared after 2001.
That's actually a lot in there that I'd love to engage further, but let Alberto and then Secretary Johnson get last words in.
Well, Ben is right. There are lots of threats out there. There will be other attacks. There will be further loss of life somewhere down the line. We will be in war again at some point in our life. We haven't seen the end of war, as the saying goes. We need to be prepared. Our forces need to be ready. They need to be lethal and able to defend the nation. But we need to keep a look at the long-term objectives. Defensively, we do two things. We save lives, but we also protect our liberties and freedoms. And we pursue both objectives simultaneously. We don't sacrifice our freedoms only to save lives. We take risks with both our society and our service members in order to protect those freedoms. And it's important to remember that. And it's also important to remember that we're working in a world and we have a vision to what that world should look like. And part of what that world should look like is a world which is less cruel than it is now. We're working not to make the world safe for cruelty, as I mentioned before, but less cruel. We're seeking to protect human dignity, and we're seeking to foster the development of human dignity around the world, which is why the strategy that the United States adopted to foster human rights around the world is so important. And as we conduct our military and intelligence operations, we need to understand what we're fighting for. We can't pick up those tools and destroy precisely that. Had we institutionalized a torture regime, had the US practice of torture been institutionalized around the world, it would have been counterproductive with respect to our long-term strategic goals and contrary to the interest of human dignity. This is why we have to be very careful about the tools that we choose. Now, I think that one of the errors of the war on terror was that we failed to factor in sufficiently both rule of law and human rights concerns in the elaboration of our policy. We treated it overly militarily. For example, we built a black site in Poland, a country that had been emerging out of the rubbles of communism and attempting to build the rule of law and a democratic government in that country. You know, who on earth thought it was a good idea to build a torture center in a country struggling for democracy, and who thought it was a good idea then to suppress collaboration with Polish investigations into torture on their own soil by Americans and others? And again, this is destructive not only of our own rule of law, but it's destructive of Polish efforts to build a rule of law. And why does that serve the U.S. national interest? This is an example of some of the errors that were avoidable errors that we could have need not have committed, and which damaged the country in various different ways. The United States is, in some respects, a crueler country today. I say that, though, knowing that this week the statue of Robert Lee was removed from a place of honor in Richmond, Virginia, which represents in some ways the closing of an ugly chapter in American history. That removal of that statue represents also another expansion of our remarkable freedoms in two generations that have seen a remarkable expansion of freedoms in our country. So we have made gains. We continue to make gains as a society, but we also make errors and lose sight of what we're all about and what we're fighting for around the world. And we need to keep sight on those objectives.
Well, we have fascinating comments, those who were able to get their Q&A posted. But given in the interest of time, I need to give Secretary Johnson a chance to respond to those last things, and then thank our panelists for an extraordinary conversation. Secretary Johnson, other comments you wanted to make in response?
The reality is that the United States government has tremendous authority in times of crisis. And it's what Alyssa said. I think the answer to all of this really does depend upon lawyers and public servants, presidents, cabinet officials, who have, as she put it, a personal and ethical code And I would add a sense of history. In the aftermath of 9/11, it became plausible for a major candidate for president to call for a ban on the entry of all Muslims into the United States. And that person got elected, all right? And the day after he did that, I was due to be interviewed on MSNBC. And I called Andrea Mitchell the day before and I said, I hope you're going to ask me about this because I have to say something about this. And I will tell you that the rule of law did not necessarily prevail in that interview because I may have crossed the line over the Hatch Act when I denounced what candidate Trump said, because people in the executive branch are not supposed to talk about politics. But I felt an obligation, a moral obligation, and the duties of my office to denounce what a major party candidate for president had said about Muslims. And it was a real setback in my own efforts in Homeland Security to build bridges to the American Muslim community. And I spent the next year in office trying to repair that breach after he said what he said. And I finally got a chance to talk to a huge convention of American Muslims, the Islamic Society of North America, in September 2016, 10,000 American Muslims. No cabinet official had ever spoken to them before. And I got some really good advice. Somebody said to me, would you please not talk to us about terrorism and being a good American? And I said, you know, that's good advice. And so I talked to them about how generation after generation throughout our history, there have been groups in this country on the margins of our society who have struggled for acceptance, but who at various points have fallen under suspicion as being disloyal or un-American, communist, terrorist. And I cited the example of my own grandfather. This is testimony I'm holding given by my grandfather in 1949 before the House Un-American Activities Committee, where he had to deny he was a member of the Communist Party. And I cited that as an example of how in this country, you too can win acceptance. If the grandfather of the future Secretary of Homeland Security can be in this circumstance, you can too. So I'd like to try to end this on a note of optimism.
Yeah. And even without asking, I think you did. I want to thank you all so much for your willingness to participate in this extraordinary discussion. We will make it available on video. I will use it in my classes. I suspect aspects of it in the future. You've helped push forward my thinking of what's happened over the last 20 years. And I'm sure that those who were able to listen had their thinking shaped as well. Thank you so much for joining us. And as we look to the next day, I hope you have a peaceful, restful, to the extent possible, September 11th memorial. So thank you again to all of you. Thanks very much. And thanks to all of you for joining us. See you next time.